Perfect. Thank you. All right. Welcome, everyone. Thank you so much for joining us. My name's Sarah Lovegrove. My pronouns are she and her. I'm the vice president of the Harm Reduction Nurses Association. I'm joining you today as an uninvited white settler on the traditional unceded territory of the Snuneymuxw First Nation. But the Harm Reduction Nurses Association is sorry, my brain stopped for a second. The Harm Reduction Nurses Association does work with individuals and organizations across all of Turtle Island and honor the life force of Indigenous peoples who have had their land stolen and who continue to resist ongoing genocide. Addressing the root causes of the toxic drug supply is deeply connected to decolonization. We also just want to acknowledge that the work that we do at the HRNA is made possible by people with lived and living experience of drug use and sharing their knowledge and experience. Without their generosity, vital life-saving harm reduction initiatives would not exist. So before I go into our speakers today and our presentation, I just want to mention a little bit about HRNA. The Harm Reduction Nurses Association is a Canadian national organization with a mission to advance harm reduction nursing through practice, education, research, and advocacy. We also offer our members a number of perks to the membership that we have, benefits, including a community of practice, or vote and contribute to national advocacy efforts on committees and working groups, education and research, including access to live webinars like this one, and roundtables with harm reduction nurses and drug policy experts, communication and networking, including professional networking opportunities with members and organizations whose purpose and mission align with the organization, as well as most recently, international recognition, including our connection to the International Drug Policy Consortium. So today we are very grateful to be joined by Corey Ranger, president of the Harm Reduction Nurses Association, and Caitlin Shane, staff lawyer at Pivot Legal Society, for their webinar entitled Protecting Life, Not Punishing Help, Understanding the Supreme Court's Good Samaritan ruling in R.V. Wilson. Today our presenters will offer an overview of the Supreme Court of Canada's landmark judgment affirming the life-saving purpose of the Good Samaritan Drug Overdose Act. So most people here who are part of HRNA know Corey very well, so I won't give his full bio, but Caitlin Shane, we're very grateful to have her here today. She's a staff lawyer at Pivot Legal Society, a human rights organization based in the downtown east side of Vancouver. As Pivot's drug policy lawyer, Caitlin takes a direction from drug user-led movements. She has appeared at the Supreme Court of Canada, the Federal Court of Canada, and the BC Supreme Court. Prior to becoming a lawyer, Caitlin worked as an outreach and harm reduction worker in tent cities, safe injection sites, and low-income housing. Caitlin is one of the lawyers who supported the HRNA also in challenging the BC government with Bill 34. So without further ado, I'll pass it over to Caitlin to get started.
Okay, awesome. Let me know if there's any issues with sound, but it seems like we're all good. Thanks, Sarah, and thanks, Corey, and thanks to you all, HRNA members and allies, for taking time out of your schedule to join us today. Sarah mentioned my name is Caitlin Shane. I'm staff lawyer of drug policy at Pivot Legal Society. I've worked with many of you quite closely in HRNA's recent legal challenge to Bill 34. That was, of course, the public drug consumption law. And I'm stoked to be here today to talk with you all about another case that I imagine will impact many of your roles and the clients that you work with. So R.V. Wilson is a Supreme Court of Canada case. It deals with Canada's Good Samaritan Drug Overdose Act. I represented Pivot as an intervenor in that case in January 2025, and I was in good company because HRNA also intervened in coalition with the Canadian Drug Policy Coalition. So with that said, many of you are probably already familiar with the decision and or the law, and hopefully I can address any sort of outstanding questions you might have. Corey, if you could switch to the next slide. I just want to take a minute to acknowledge that I myself am joining from the stolen lands of the Musqueam, Squamish, and Tsleil-Waututh nations in so-called Vancouver, BC. That's where I live and work. Drug laws are not applied equally. The law we're talking about today has not been applied equally. And so I'm really grateful to Indigenous people for stewarding this land and for guiding our work in shifting the colonial default. We obviously still have a ways to go, but it's important that we remain steadfast in that effort. Next slide. So I'm just going to give a brief overview in terms of what I'll be talking today. I will be talking about the Good Samaritan Drug Overdose Act. I'll probably refer to it as just the Act going forward because it's a bit of a mouthful. Then I will get talking about R.V. Wilson, which is, of course, the Supreme Court of Canada decision. We'll talk about some of the facts that gave rise to that case, what it is that the court was contemplating in that decision, the arguments that were put forward, and the ultimate ruling. And then we'll just talk about what that means for the law itself and an overview of what kinds of protections we can expect from the Act. We'll have time for some Q&A at the end, and hopefully I'll just be talking for like 25 minutes, and then we'll have a good amount of time for discussion. So, next slide, please. Yeah, and two, I just also just want to put forward two notes before I get into it. One is that, this is a harm reduction law. It's not a solution to the drug toxicity crisis. I think we all know that by now. It's important to protect laws like this, even though they might offer just nominal protections. But we saw that this case was, just one further step in the war on drugs and the war against people who use drugs. So while we fight for laws like this, it is so incredibly important that we also advocate for a regulated, safe supply of drugs. That's the only way that we're going to actually stop overdose deaths. So, this is one piece of advocacy that must always happen alongside that bigger advocacy piece. The other thing I want to mention is that this is a law that provides legal protections to reduce fear of calling 911. Fear will still persist. This law does not take care of all of that. As we'll get into, there are many things that police can arrest for besides simple drug possession at an overdose. So it's totally understandable that people will continue to experience fear of calling 911. And the other piece is that oftentimes when police are attending, I hear this all the time, they are oftentimes interfering with overdose response. And so that is another reason why people might fear or avoid calling 911 because it can be a matter of life and death if someone is coming and interfering the good work that you're trying to do. So, in Vancouver, it doesn't always get followed, but the police do have a policy of non-attendance at overdoses. So when you call 911, EMS will arrive and presumably not police in most cases. That doesn't always get followed, but it is something to consider advocating for in your own communities as just one more way to reduce that fear of calling 911. So let's talk about the law. The Good Samaritan Drug Overdose Act was passed by the Canadian government in 2017. It was introduced at the time by Liberal MP Ron McKinnon. And ultimately, what it did was amend the Controlled Drugs and Substances Act, which is Canada's overarching drug prohibition law, to include certain limited legal protections for people who find themselves at the scene of an overdose when EMS or police arrive. The idea behind it was that people were regularly avoiding calling 911 or otherwise avoiding remaining at the scene of the overdose, whether to provide CPR or naloxone or to talk with emergency help when it arrives, because they feared being criminalized. And that was/is a very valid fear because prior to this law, anyone could be arrested for anything, anywhere, including at the scene of an overdose. So, Parliament, which is Canadian lawmakers at the federal level, decided to pass a law that alleviates some of that fear, again, by providing some limited legal protections to people at the scene of an overdose. Of course, Parliament would say that when they drafted this law, it was striking a balance between legal immunity to promote the saving of a life and enforcing the criminal law. And so, obviously, many of us here probably have our own opinions on the proper balancing of life versus criminal law enforcement. but this is Parliament. This is not Pivot and HRNA, unfortunately. So let's look at what Parliament landed on. We'll look at the actual text of the law itself. So if you could go to the next slide, here is what the law says. So again, this is amendment to the Controlled Drugs and Substances Act. In the law, right above these provisions, you have the prohibition that says you cannot possess drugs for your own use. That's called simple drug possession. Simple drug possession is just possessing illegal drugs for your own use. It is not possessing drugs for the purpose of sharing them, giving them away, trafficking them. It is just drug possession for your own use. Now, below that prohibition, you have the text of the Good Samaritan Drug Overdose Act, and it's the exemption provisions. So I'll just read the first part of this subsection. No one who seeks emergency medical or law enforcement, so that's police or EMS, 911, because that person or another is suffering from an overdose, is to be charged or convicted under simple drug possession prohibition. And you'll notice that I've underlined charged and convicted. And you'll also notice that the word arrest is nowhere to be seen, right? Just charges and convictions. And just for a moment's clarity, the differences between arrest, charge, and conviction. So an arrest is carried out by police when they have reasonable grounds to believe you've committed a crime. Just because you've been arrested doesn't mean you're going to be charged or convicted, but that is kind of the first step of interaction with police. A charge is a formal accusation by the Crown prosecutor that you've committed an offense. It's the first stage of the proceedings against you in a court. So usually after an arrest, police will make recommendations to the Crown prosecutor saying, I recommend that you charge them with XYZ. And then it's up to the prosecutor to decide whether or not to proceed. Conviction, of course, is when the court finds you guilty beyond a reasonable doubt. So that's the last stage to determine your guilt. The provision below subsection 5, I won't get too deep into it because it remains the same before and after Wilson. But just for your own knowledge, what it is a provision that deals with breaches of conditions. So the act says that you won't be criminalized at the scene of an overdose for breaching a court condition that relates to simple possession offense. So let's say last month I was charged with simple drug possession. And then I was out on bail with the condition that I not go to Maine and Hastings. And then I find myself at Maine and Hastings and my friend overdoses. If I call 911, even though I'm breaching my bail condition not to go to Maine and Hastings, I won't be arrested for that breach because it relates to an underlying simple possession offense. Now, if that condition not to go to Maine and Hastings was part of, a charge for trafficking or weapons possession or whatever, my breaching that condition is still an arrestable thing. But because it's related to simple possession in this case, that's your immunity. So again, very limited protections we're talking about here. Now, I'm showing you the full text of the act because really what's at the heart of the Wilson decision is the question of legal interpretation. What does the law, and in this case, the Good Samaritan Drug Overdose Act, mean? So I always say, well, I don't always say this, that's incredibly, I don't walk around. I always say the law has three sides. You've got what's on paper, so the actual written word of the law, like what we're looking at right now. You have what the common law says, that's what the courts say in their written decisions about the law. And then you have the enforcement of the law by police at street level. One would hope that these three sides are in alignment and relatively seamless, but as I'm sure many of us have witnessed or experienced, there can be a huge disparity between what the law says on paper and how it plays out at street level. And I shouldn't even say that police enforcement is a side of the law because oftentimes police enforcement is unlawful and not by the book, but it's the reality of people's experience, right? It's however lawful or not, it's how people oftentimes are interacting with the law. So that's why this case is interesting, I think, because it seeks to interpret a law that is not always being enforced the way it was intended to be enforced. And because there's a difference between what the act says on paper, what it should say or mean, and then how it gets enforced. So if you could go back to the next, if you could go to the next slide, please. R.V. Wilson. I just like this actual photo of David Eby, but it doesn't really have anything to do with this case. So, going back to 2020, we are in rural Saskatchewan. Paul Wilson is hanging out with some friends in a parking lot. They're chilling with their car. One of their friends, a woman, suffers an overdose. And fortunately, Paul and his friends respond in the way we all hope people would respond when an overdose occurs. They call 911, they start doing CPR, they administer naloxone, and fortunately, they're able to save this woman's life. Now, police roll up and they start poking around, and pretty soon they go ahead and arrest everyone at the scene for simple drug possession. So they arrest Paul, they arrest the caller, and really unfortunately, they also arrest the woman who overdosed. Then, incident to that arrest, they begin a search of people and the premises. And in the course of that search, they find some illegal weapons and some stolen merchandise. And ultimately, Paul is charged for a range of other offenses, including weapons possession, but he is not charged or ultimately convicted for drug possession. So the thing that he was originally arrested for never materialized into charges. But the thing he was originally arrested for led to a search and seizure that ultimately led to different charges and convictions. That's probably because police maybe understood that a person can't be charged or convicted of drug possession at the scene of an overdose. But arrests for drug possession at an overdose, they say that's fine, so long as you don't follow through with the next logical steps of charge and conviction. Why would police say that they could still arrest but not charge or convict for possession? Lots of reasons. Police like to use drug possession as an easy launching pad for investigations and the ability to search and seize, as they did here. But also, if we go back to the text of the Good Samaritan Drug Overdose Act, as I had underlined in red, the act protects against charges and convictions, but it stays silent on the issue of arrest. So if we fast forward to Paul Wilson's trial at the Saskatchewan Provincial Court, the parties are debating this very question. Next slide, if you could. So the issue or the question is, can police arrest for simple drug possession at the scene of an overdose if no charge or conviction for simple possession results? Because, of course, those charges and convictions can't result according to the text of the act. Or really, what does the Good Samaritan Drug Overdose Act really mean? So, Saskatchewan and the RCMP, not surprisingly, said that arresting someone for possession at the scene is fine, so long as a person isn't charged or convicted for it. They say Parliament chose not to include protection against arrests in the letter of the law. If arrests were meant to be included, the law would say so. End of story. Wilson and many of the intervenors, Pivot, HRNA, took a different approach. Statutory interpretation, or the fancy word for what does the law mean, involves more than just a plain reading of the text. Getting to the true meaning of a law when it's an issue involves, yes, looking at the words of it, but also considering what our lawmakers intended when they drafted the law. What were their goals in drafting it? How do we make sure we interpret the law now in a way that reflects what was meant and also reflects the reality of overdoses, the crisis, human beings, and natural fears of police? Um, Next slide, please. So this is like, that stars, they're just like us. This is the fucking boring version of that game. It's Parliament. What were they thinking? So yes, th this question forces us to ask what Parliament was thinking when they drafted the act. When Parliament introduced the bill and debated it before it became law, what were they saying about it? What did they want to achieve? And here are some of the quotes. We cannot arrest our way out of this problem. The two most common barriers to calling 911 during an overdose event were fear of arrest and being on parole. Unfortunately, young people especially are afraid they will get arrested or that their parents will find out what happened. These fears force the witness to choose between saving a person's life or being arrested and charged. Okay, so you have parliamentarians across the political spectrum talking about arrest, and the fact that we need to protect people to be able to call 911 and have them not fear that they're going to be arrested or charged or convicted. Um, Next slide, please. Other things that Parliament was thinking, they were talking about the fact that an overdose is a medical emergency and that it shouldn't be a fishing expedition for police. They were talking about the fact that fear of arrest alone is enough to deter people from calling 911 during an overdose. And they talked about the act being a piece of harm reduction legislation, with the goal being to save lives primarily. Based on these considerations of Parliament, the parties and the intervenors at the Wilson trial talked about the need to interpret our laws with an open mind and in accordance with evolving realities, aka raging drug toxicity crisis, the need to interpret drug laws without stigma or bias. That's something that HRNA said. The parties, or rather the respondents, and the interveners also argued that arresting people on a technicality will mean a loss of faith in the law and the criminal justice system. Do you think that Paul Wilson and his friends would ever call 911 again if we interpreted the law the way that Saskatchewan wanted us to? Probably not. The law should not be used as a sort of gotcha against civilians. And that's sort of how we interpret this interpretation to be. Oh, don't worry, you won't get charged or convicted, but you might get arrested and then they might search and seize you and then you might get convicted for something else. Like in the complexity of that, the fact that you had a courtroom of, 20 lawyers debating the intricacies of this law was itself proof enough to me that like this law isn't going to work, right? If we can't properly understand what it means, how do we expect someone at street level in the middle of an overdose crisis, in the middle of an adrenaline pumping moment of responding to an overdose, to calculate, am I going to get arrested or charged? Or like, it's not reality. Um, Next slide, please. So fortunately, the Supreme Court of Canada agreed with the arguments of most of the interveners and the respondents. In October 2025, so just last month, they confirmed in writing that anyone at the scene of the overdose, whether it's the caller or a bystander or the person who overdosed, will not be arrested, charged, or convicted for simple drug possession. And there's lots of really great language in that decision that I think will help our future advocacy efforts. I won't read this full quote, but toward the end, there's an acknowledgement that says the strong disincentive created by the threat of arrest and the consequences that might flow from such an arrest would substantially undermine the life-saving purpose by dissuading people from seeking help from emergency services in the case of a drug overdose. And that's really what this law is about, right? If the goal is to save lives, we shouldn't be arresting people on a technicality. Yes. Oh, you read my mind, Corey. So this is kind of the overarching summary of what the law does and does not do. It really, like, the only core sort of difference is that now the Supreme Court of Canada has provided clarity that it's not just charges and convictions, it is also arrests for simple possession that are protected against. Much of the rest is the same, right? Anyone at the scene of an overdose, that includes youth, are protected when police or EMS arrive. It continues to protect against breaches of conditions where the underlying offense was simple possession. It does not protect against arrests, charges, or convictions for any other crime besides drug possession. It does not protect you if you have an outstanding warrant or if you've breached conditions that are unrelated to simple drug possession. I also just want to note that police have sweeping investigatory powers, so they can still rock up to an overdose and start investigating for things. And we know that they're often doing that. And so that's also part of why at the start I made that point about, really needing to advocate for policies of non-attendance for police at overdoses so that we can just avoid that from happening altogether and further reduce the harm of, the fear of calling 911. Is that the end of my slides? It is. Okay. So yeah, that's it for me. Again, we'll have time at the end for questions and answers. Um, but yeah, that's all. I'll
That
turn
was
it over.
wonderful. Thank you so much, Caitlin. You do a really excellent job explaining something that is, relatively complicated and nuanced. So thank you for being here. And thank you also for your role in the case. I'm going to spend just a little bit of time now talking about what's nursing got to do with it. What did we do from the HRNA perspective? Why is it important? Why do we feel the decision is important? And then we'll conclude with a Q&A opportunity with both myself and Caitlin, and we'll stop the recording during the Q&A just in case folks are more comfortable speaking up or going off camera when the recording is off. In the case of R.V. Wilson, the HRNA was one of 3 intervenor organizations that made up what I believe they dubbed the Harm Reduction Coalition that filed submissions before Supreme Court of Canada to underscore the life-saving intent of the Good Samaritan Drug Overdose Act and the real-world consequences of narrowing its scope. I think it's really important, as Caitlin already stated, just to reiterate that, the issues that this law seeks to address are very important. The reluctance to call 911 due to fear of being charged and arrested, the stigma and the judgment that comes with being arrested, wanting to ensure protections for young people who are especially fearful of arrest, and some of the things that we really tried to reiterate or iterate in our case, is that as nurses, oftentimes we're teaching people how to administer naloxone. We're providing the education. One of my earlier jobs as a nurse in harm reduction was the take-home naloxone project nurse in southern Alberta. And so, we're very used to telling people, stay with the person who's overdosed. We need you to stay with the person who's overdosed, and the Good Samaritan law will protect you. I recall working in harm reduction before we were talking about fentanyl all of the time. And when fentanyl arrived in the drug supply and we started trying to rapidly scale up naloxone programs, it was a genuine fear that I heard from people who were getting the training, that they were concerned about being arrested. They were concerned about being charged. And before the Good Samaritan law came into effect, there were a lot more stories of people being left at the scene, of people maybe getting 1 dose of naloxone or being put into recovery position and 911 being called, and then people leaving for fear of arrest and criminalization. And so these have very real implications. And so, you know, even just as a nurse who gives education to people on how to use naloxone, changing our training. You know, if you imagine having to tell people, stay with the person who's overdosed, the Good Samaritan Drug Overdose Act might protect you. That kind of uncertainty would lead to a lot more people being abandoned at the scene of an overdose. We also talked about, you know, a little bit about the emotional toll of finding people who have passed away from avoidable death. And so, you know, many nurses who work in harm reduction and outreach, myself included, know the feeling of finding someone who's deceased after being left for too long and too late for resuscitation. And so we argue again to eliminate that or reduce the likelihood of that moral distress. It is imperative that this law be protected and kept as clear as possible. And we also have to do a bit of contextualizing the crisis, like why clarity of the law has never been more important is because we have a toxic and unpredictable drug supply that continues to get worse and worse and more volatile. In a recent BC Supreme Court case that actually Pivot and HRNA and Canadian Drug Policy Coalition were involved in, we actually heard from BC Supreme Court Justice Hinkson that I've already set out that British Columbia is in a public health emergency. As part of these circumstances, the plaintiff argued, and I accept the unregulated nature of the illegal drug supply is the predominant cause of increasing death rates in British Columbia. And so we know what is driving death and injury when it comes to this drug poisoning emergency. And what it is what we see on the screen here. This is the most recent update from the BC coroners, substances detected in expedited toxicology. And there's more and more analog benzodiazepines, other substances that are being found in the drug supply. And so we've actually, you know, it's been 3,505 days since BC declared a public health emergency, and that equated to at least 17,580 deaths since an emergency was declared. Across the country, at least 53,000 Canadians have died since January 2016. And so the drug supply and its volatility and its unpredictability means that we need to have these laws and we need to have clarity in these laws because, you know, staying with someone at the scene of an overdose is a matter of life and death for people. And we also should acknowledge that, you know, a lot of deaths actually occur indoors and behind closed doors and in places where people may be, you know, even more fearful of calling 911 and where it is less likely that someone would be found because they're outside and then they're in the public eye. And so there's a lot higher likelihood of people being left at the scene when it is in a private residence. And so we want to make sure that everybody anywhere is comfortable calling 911 during an overdose. And, you know, the reason why I'm talking about the drug supply, not just because of the risk for toxic drug death, but also because of the long-term health implications that we're starting to learn about. So it's actually not just risk of death that we're concerned about when it comes to this drug supply. It's risk of irreparable harm in the form of brain injury as well. And so a recent update to a 2023 study put out by the BC Centre for Disease Control has shown that people in British Columbia who experience toxic drug events are 19.5 times more likely to have encephalopathy compared to those who did not experience toxic drug events. Encephalopathy is an acquired permanent brain injury. And so time is of the essence, and making sure someone gets access to regular and effective rescue breathing to prevent brain injury is imperative. And so that means we need to make sure that people are confident in calling 911 and that they're prepared to stay with people because we need to keep supporting them until emergency services could take over. There is hefty amount of evidence out there that shows that the naloxone programs have been extremely effective in at least reducing the harm of this toxic drug poisoning crisis. What I have up on the screen here is from an early analysis that the BC CDC completed, where they found during the period they studied that overdose deaths would have been at least twice as high without emergency harm reduction services. And one of the main interventions in those emergency harm reduction services was the widespread availability of the take-home naloxone project. Toward the Heart in 2021 noted that the availability of naloxone as an emergency response intervention has been critical in saving lives. Modeling estimates that from January 2015 to March 2021, more than 3,000 deaths were averted due to take-home naloxone. And for those of us who were actually teaching people and providing them with the kit early on in the take-home naloxone project, we know that being able to clearly articulate what the Good Samaritan law can and can't do was an effective tool in ensuring that naloxone was used and that people were supported at the scene. HRNA's contribution to the court, we were really trying to emphasize that this law is enacted to encourage people to call 911 during overdoses without fear of criminal consequences, and that it should be interpreted through a public health lens and not a criminal lens. That overdose cause not only death, but serious physical, psychological injury, that families and communities also experience emotional and social harm, and that, the law itself should be intended to address this full range of consequences. That the public must understand what the protections are offered within that law, and that any ambiguity about police power can deter people from calling 911. And that interpretation should clearly bar arrest for simple possession when someone acts as a Good Samaritan. And then more broadly, that interpretation should be grounded in science and not stigma. The protections apply to people with substance use disorder, but also talking about the importance for people who use occasionally, young people, people who are using for the first time. And arresting Good Samaritans does not enhance the safety. But what it does do is it deters emergency calls. So yeah, we think that this is a really great victory. We are very pleased with the court's decision. This means that we can confidently, as nurses, reassure clients about that immunity and about the clarity of the law, which we hope then will reduce barriers for youth, parents, people at risk of criminalization, from calling 911, that this can help enhance or potentially rebuild some trust in emergency services. And that, of course, or our ability to respond to overdose is in alignment with evidence and ethics, and that when we're teaching people, we're not, potentially putting them at harm because they're going to be arrested or charged. I think some of the lessons that I've learned through this, because I'm not a lawyer like Caitlin or DJ or any of these amazing people that show up and support the HRNA, is that clarity is essential, that immunities have to be broad and simple, that overdose response needs to be framed as a healthcare approach, not one from law enforcement. That we need to keep consulting with youth, and we need to keep addressing the particular heightened risks that youth experience. That we need to stay vigilant, and we need to guard against administrative and police creep at all times. And as Caitlin said, much more articulate than I could ever be, this is a harm reduction law. This is reducing a law. This is reducing harm of a broader set of laws that is causing harm. And so we need to see legal regulation, and we need to keep pushing for some of those big systemic changes as we protect these types of laws as well. So that is it for our presentations today. And I will just show off my references and then I'll stop sharing and turn off the record, and we can have some questions and answers.
Okay, but wait, Corey, I wanted to say one thing in the
Please do.
Okay, so thank you all for being here. I always like to end with a little pitch. You know, legal defense, legal challenges, charter challenges, this these are important steps for advocacy. They are nothing without a diversity of tactics. So it's one avenue that we pursue while we do all the other kinds of great advocacy that we must do. As lawyers, our case is only as strong as the evidence we can rely on. The evidence comes from you all. And so during the Bill 34 challenge, many of you, including people on this call, were incredibly supportive, provided written affidavits. And I just want to keep that line open and underscore the importance of that. When we don't have affidavit evidence, we can't make arguments. We need to directly show the court this is what this law looks like in practice. Here is a nurse or a social worker or a person who uses drugs or all of the above who experiences harm from this law. And so I know that writing affidavits can seem very scary and intimidating, but it is so incredibly important, and it is far scarier and more intimidating for people who are actively being criminalized on a daily basis. So it's really important that we step up to do that good work. The other thing I just want to pitch is, we were talking about drug use occurring alone and the risks there. I'm currently looking into questions of guest bans and restrictions and the uptick that we've seen over the last few months. So if you are a person who knows of total guest bans happening in buildings, if you yourself have been blocked from entering a building to meet a client because of guest policies, please reach out to me. Yeah, that's all. Thanks.